And in today's world, over the last several years, I would say particularly the last 5 years, maybe 7 years, our jurors are a lot different now. Probably one of the biggest things that I can think of course, is the fact that when they're sitting on the jury, whether it be a municipal magistrate jury of 6 people, or it be, a common general sessions or court of common pleas jury of 12 people, is that they're not having their phone with them anymore. And so when they're sitting there, whether it be for half a day, 5 days, 10 days, 15 days, no matter how long the trial is, that period of time that they're sitting there having to listen to the case and not have their cell phone or their laptop, that's a very different world that we live in now that we didn't even live in 10 years ago. And so knowing how much they're going to pay attention, how much they really either going to actually take in what you're talking about or what point you're trying to prove is difficult to know, because they're usually in a position that they're not used to being in. A lot of them have not been in a school setting or even a classroom type of setting where they've had to sit and listen just to one thing for long periods of time. And even if they have, they've still had the ability to be able to check their phone or, again, look at their laptop, go online. When you're sitting in that jury box, you don't have any of those options. So for a normal person to take a stop from their everyday life and sit there and work vigorously on having to listen to a trial, listen to a case for 6-8 hours a day, several days, that can be very mentally wearing. And sometimes there may be some things within the case that you really are trying to hammer home that ultimately they just don't hear, not because they're not present, just because they're not listening. They're thinking about their job or their family members or other things going on in their lives, or just really anything but the case, simply because their mind is wandering, because they're used to sort of being able to have that contact, being able to pull out their phone and text message someone, email someone, call someone. And when they're sitting there all day long, it can be mentally draining. And I've learned that from speaking with a lot of jurors. And unfortunately, that can drown out some things within the case that you were hoping for would help. On the other hand, sometimes those things that are drowned out can be a benefit to you. And that's one side of the jurors that's always interesting, being when you have the opportunity. Obviously, jurors, after cases have been completed, they don't have to speak with you, but when they do speak with you, it's always interesting to find out what points of the case they thought were important, what witnesses they liked, what witnesses they didn't. And every time there's usually a couple of things that you're dead on and you're really nail it on the head that were important and mattered to them, and it was somewhat influential. And every time also there's a couple of things that they talk about that either A, you feel like they didn't understand why that person was even a part of the case or why that evidence was in play, or B, they're really just completely off and you're just shocked because it was just the way that they actually took it in. It was a way that you never saw it, and it's really maybe because they missed another part of the case earlier, or maybe afterwards they didn't connect the dots together. Because by the time that you've put the trial together, no matter if you're on either side, the defense or the plaintiff in a civil case, or the prosecution or the criminal defense in a criminal case, you know that case in and out. And it's sometimes a little bit difficult to really pull yourself away from it and not have all the sort of minute details of how you're painting the story. And remember, the folks that are sitting on that jury are hearing it for the first time that day, that afternoon, that few days. And the longer a case goes, the more that they may even forget, what they heard from the very beginning. So that's another step that has to come back into play when you're closing out the case, is to try to sort of rehash a lot of the things that you went over within your closing statement, just to try to bring it back up. But at the same time, you don't want to insult the jury and make it feel like that you're teaching kindergartners, because these are all grown adults. And these are adults that, are there because they're adults and they're citizens that are asked to serve their society, and you want to believe that they listen to the court's orders and the judge's orders as to how important their role is, and most of them do. Unfortunately, there are the ones that sometimes either A, don't take it seriously enough, or B, are a little upset that they got picked to be a part of the process, and therefore in some ways almost rebel against it. And again, you see these types of things from every case, and so when you're picking your jury, knowing what type of people you should pick is difficult, and it really depends on what type of case. But even then, you're still just making guesses based off the little bit of information that you have. In South Carolina, we don't gain a lot of information. Other states, you can actually speak with the potential jurors, ask them questions yourselves. Those aren't things that we're able to do here. We basically know whether they're married or single. We know their age. We know their occupation or former occupation. If they are married, we know what their spouse does for a living. And really anything beyond that, there'll be a few specific voir dire questions that the judge will ask, but you don't have a whole lot of information beyond that. So one thing that, for instance, I always pick out of a person is if they stand up in their court and they look angry, I never pick them. And the reason I never pick them is because I don't know if they're angry at me or they're angry against the other side. And it's not worth the 50-50 guess on what that answer may be. But you'll see people that look disgruntled, and you don't know why they're disgruntled. But other lawyers look at that different and say, hey, I'll take the risk that they're really mad at the other side. I want that juror. So those are just examples of things that you really have to learn through practice. And you're not always going to make the right decision. Sometimes speaking with jurors afterwards, you'll say, you know, what did that juror think, or what did this one think, maybe one you didn't talk to? Well, they didn't really like you. They thought you know, were too dramatic or were asking too many questions or harassed a witness. And then you think to yourself, oh, well, that was the one I thought was really paying attention and was, you know, following along with what I was saying. So the facial expressions that the jurors make throughout the trial can also be misleading. I've had jurors bawling, crying during a closing in a criminal defense case that I was a murder of a young child. And I felt very strongly about the case and thought that we had proven that there was very much reasonable doubt. I was completely wrong with that thought process. They were crying because they felt bad that they were going to have to find my client guilty of murder. They weren't crying because they thought he was innocent of what had happened. So that's just one easy example of something that you can completely misread because, again, you're not speaking with them, or if you are, you're not speaking with them until the case is completely closed off. So that's an interesting part that we have to deal with in any type of case. With a judge case, which are few and far between, most people always choose jury cases. It's a little bit easier to understand. They're a little bit more direct. I don't have a lot of cases experience where you would ask for a judge unless it's a very serious legal issue that you feel like the nature of the issue is something that really someone with a legal background needs to handle. The last case that I had was a murder case, and we were pleading our client not guilty by reason of insanity. So essentially the issue at hand was whether or not he was insane at the time that he murdered one person and attempted to murder another person. So we did put that when the solicitor's office and my office agreed to put it in front of a judge as opposed to a jury. And it was a very interesting case in that you're not arguing the facts at all. You're stipulating, which means agreeing to what happened as far as the physical actions within the trial. What you're fighting over is what the mental state of your client was. We were fortunate enough to get a not guilty on that case, but that would be something that would be very difficult to put in front of a jury. In fact, I'm not familiar with any cases in South Carolina's history where a client was found not guilty by reason of insanity by a jury, and that's simply because the standard is so high. And also just the conceptualizing that you're saying, hey, this person did murder this person yet, or injured this person, or whatever the case may be, yet they're still considered not guilty based off just mental components. That's a hard concept for anybody, and that's the type of case that you would put in front of a judge or prefer to put in front of a judge over a jury. On the civil side, sometimes you also have some very meticulous type of fact patterns that lead to certain types of understandings of the law. Now, of course, the judge is the judge of the law and the jury is the judge of the facts. But if it has some technicalities in it, you do occasionally see civil cases that are also just put in front of a judge by both sides, and so they want the judge to make the final determinations that he or she thinks based off what they hear from the factual side that's presented, but of course, more importantly, the legal issues that coincide with it. Because sometimes no matter what a judge may tell a jury, they still don't particularly understand what the legal issues are. Or maybe they try to understand it more than they should, and they start manipulating the law to what they believe it to be based on the facts. But in reality, the way the system's supposed to work is they are the judge of the facts. They're not the judge of the law. As far as other sort of parts of a case, I think one thing, sort of working it backwards, just off the top of my head, one thing that I think is important, and I've got several cases right now that I'm doing this on, is when people ask me also, what do you do when a case starts? Well, when a case starts, it's overwhelming to the client. It's overwhelming to their family and their friends when we're talking about serious types of cases, because obviously the day before this, nothing had happened. They had not shot someone in what they claimed was self-defense. They had not gotten a letter from the United States Attorney's Office saying that they had been involved in some sort of white-collar crime, fraud, the different things like that. And so from there, there's so much level of just scare. Just fear is the best way to put it, and unknowing as to what the next steps are. But for an attorney, the steps are always going to be the same from a procedural standpoint. You know that you're not going to get a lot of the evidence, if barely any at all, prior to, for instance, their bond hearing. You know that you're not going to get a lot of the evidence is for their pending charge for several weeks, even months. So the process of sort of just setting up for the case is pretty much the same on any case. And in reality, your true work past just helping the family understand the process of the case and how it works through the system. People ask me also, what do you do when a case starts? Well, when a case starts, it's overwhelming to the client. It's overwhelming to their family and their friends when we're talking about serious types of cases, because obviously the day before this, nothing had happened. They had not shot someone in what they claimed was self-defense. They had not gotten a letter from the United States Attorney's Office saying that they had been involved in some sort of white-collar crime, fraud, the different things like that. And so from there, there's so much level of just scare. Just fear is the best way to put it, and unknowing as to what the next steps are. But for an attorney, the steps are always going to be the same from a procedural standpoint. You know that you're not going to get a lot of the evidence, if barely any at all, prior to, for instance, their bond hearing. You know that you're not going to get a lot of the evidence is for their pending charge for several weeks, even months. So the process of sort of just setting up for the case is pretty much the same on any case. And in reality, your true work past just helping the family understand the process of the case and how it works through the system is just getting ready for it. And then it really starts to play into where the true, I would say, inner functionings within a law office, whether it be civil or criminal, really come into play from the standpoint of looking at the case once you get the evidence, determining how they got that evidence, was that legal, and whether or not how that evidence you believe would appear within a case, within a trial setting. Is it something that you feel like that they've reached that burden? Civil's a little bit different in that you understand the basis of why someone has come to you, or whether you're defending them civilly or you're on the plaintiff side, and then from there you get a lot more fact finding through, of course, depositions and the different interrogatories that you're going to send out, and questions that you will ask and provide the other side to really sort of play out the facts. Or on criminal, it starts completely different. In South Carolina, we do not have criminal depositions, in that you're not allowed to depose a police officer prior to any kind of hearing. The only time that you would be able to speak to a police officer outside he or she willing to speak with you on their own accord would be within a preliminary hearing. And then after that, it would simply, of course, be the actual trial. It's completely different on the civil side as far as the exposure of understanding what someone thinks happened, how it happened, what a doctor thinks as to if that's actually what happened and what caused an injury, if it was, for instance, like a personal injury type of case. So a lot more information really comes out over a step-by-step process in a civil process case, as opposed to in a criminal case where you really sort of get one file dump of information. And then there may be some other things that trickle in through the investigation, and then that's what you work from. You just work from picking that apart. Now, there may be other witnesses that come forward, or evidence may come back, of course, things like that you do see on television, DNA and fingerprints and different things like that may come into play later, or other witnesses. Occasionally they may find more recordings, or if your client is in jail, he or she may make their own recordings through phone calls or letters that are also could damage their case. So there can be some secondary factors that come in on a criminal case, but generally speaking, once you get a large majority of what they call the Rule 5, the discovery materials, that is what both sides is working off of to either prove the case or for the defense, of course, to disprove the case. So the process between the criminal and civil are very much different, very much more methodical on the civil side as opposed to the criminal side. Then again, also on the criminal side, you may work in a different sort of way, in that you may become sort of not just defending in a defense mechanism, but also defending in a proactive way, and that's finding other witnesses, or maybe going back to witnesses that were originally in a police report or an investigation, and seeing if that's exactly what they said, or 6 months later, do they still remember it to be that way, or is there other witnesses that actually no one ever spoke with in the first place who could be key to your case and key to potentially going forward with the trial, or disclosing that information to the prosecution to where perhaps the case goes away altogether, or you reach a plea bargain that you're worth taking. So those are sort of proactive ways that defense goes beyond just taking the information that's provided from the police department through the solicitor's office or U.S. Attorney's office, depending on who's handling the case. That's probably all that I want to get into details on the process. I'm open to answering any questions anybody may have, sort of some more generalities, and we can kind of go down those different directions. But the main thing I wanted to show today, or try to understand for people that may not be real familiar with how the process works, is sort of the way you look at the cases, how the cases unfold. And I think one thing I probably haven't mentioned, but it should be evident from what I've said, is that all this happens over quite a long period of time. When you watch a movie or you watch a TV show, it seems like they're arrested one day and they're going to trial the next. In reality, if a person was arrested, let's just say, to make it easy, for armed robbery, if that person was arrested, in September of 2019, if it went all the way to trial, there's a good chance that trial wouldn't come till sometime in 2021. So a year and a half, 2 years, maybe even longer. There's several different reasons for that. Part of that is because of the caseload that the prosecution office has to have, and the cases that are ahead of that. It also comes to when you actually get the evidence, the scheduling of the court, and several different factors. So this process doesn't happen fast, and that goes back to what I was saying earlier, as far as looking at it from the standpoint of the person that's been charged or their friends or family. It happens quickly, so quickly, it's a nightmare in their lives, and then they have to sit there and sort of just carry the burden for that long period of time while the case functions through the system. Civil side can be the same way. Yes, there can be quick settlements, but often you have cases that are leading all the way up until a trial that maybe take 2 to 3, 4, 5 years even, depending on the complexities of the case. So rarely ever is there going to be a case, unless it's a very small civil issue, something like a landlord-tenant, or anything under $7,500 goes in the small claims court. Those things can move within a few months. Criminal side, of course, minor municipal or magistrate charges such as an open container or simple possession of marijuana, underage possession, different things like that can move quickly, and sometimes not even really include more than just the police officer and the defense attorney, depending on the process. But anything of substance is going to take quite a long time on both the criminal side and the civil side, and that doesn't matter whether or not it's a plea or a trial. That's also looking at it from the standpoint, and on, of course, the civil side, if it's a trial or a settlement that is reached. So I think that's one thing that, from the general public standing, you don't really think about how long these things really take, unless you're involved in some way. If somehow it's your loved one that's been charged with a crime, or if you were a victim of a crime and you want justice for yourself or your family. And then, of course, on the civil side, if you've been accused of something and there's monetary value at stake for yourself or your business, or if you're the person that feels like you've been hurt or injured or somehow damaged financially by another person or by a company. Of course, everybody then wants those results as quick as they can, but they're not usually going to come that fast. I think that's probably where I'll stop as far as from a procedural standpoint. If there's any kind of specific questions about any types of cases or anything that they're really wanting to know more about, I'm more than happy to answer any questions. But the biggest thing is sort of just having an understanding of how the process works. Yes, ma'am.
Okay, the phrase that I don't remember hearing so often as I was growing up and all, bring somebody to justice. It just seems to be, was that always in the lingo, and I missed it?
It's just like any other catchphrase. It's something that you hear, just rhetoric. There's a lot of rhetoric in a lot of cases, and particularly if you're involved in high-profile cases, where both sides will try to play it against each other and use language like that, almost in an attempt to have momentum to their way. Like, you think bring someone to justice, what do you think? You think of like
comic book character, right? You know, basically the person, the police and the prosecutor, they're bringing justice back to society by arresting this man or this woman or this group of people and stopping them from the crime that they're committing. So it's definitely a catchy term that you hear, and it's something that you'll often hear in rhetoric from a solicitor or a district attorney, outside a courtroom in front of a bunch of news cameras. And they want to play it as they're the good guys, and that they're just trying to clean up the streets, just like they say in the movies, right? But in reality, when you're truly in the courtroom, terms like that aren't allowed. They're not used. They may be used within a closing or an opening to a jury, but they're not something that's supposed to be considered by a jury in their decision making. They're only supposed to look at, of course, what the judge tells them to and what is put on record, not just the personal opinions of, for instance, someone that would say something like that, which would usually be someone on the government side.
Okay. I can ask you questions all day. This thing they use on show on TV about the person accused of a crime has to be able to participate in his defense. Is that an issue that comes up very often? What?
That's actually a really good question, and it comes up a lot. And the fact is, you can represent yourself in any type of case. First and foremost, as pro se is the term they use. Also, an old saying that you hear that people use in regards to criminal cases specifically is anybody that represents themselves has a fool for a client. And it's true. And I don't just say that because I'm an attorney and I want to be hired by someone. You really need someone that is not emotionally connected to the case. And you also need someone that's legally trained, because I can't tell you the amount of times I've tried to help people put the toothpaste back in the tube because they have represented themselves. Usually it's on small things, but sometimes it's on bigger cases. So you have that right. I'll give a 2-second story. I had an individual that worked at Boeing here, and this is several years back, and he had been charged with criminal domestic violence. He and his at-time girlfriend had gotten an argument. Police were called. He ended up going to jail. He hired me for the case. We started filing in the regular process. It was at a municipal court level, so it was the lowest level. He called me a couple weeks before the trial was coming up and said that I could keep the money, but he didn't need me anymore. And I said, well, did you hire another lawyer? Because you have the right to do that if you didn't think I was doing my job. Law is just a service. And he said, no, I didn't hire another lawyer. There's nothing wrong with you or anything. I'm just going to go to court and handle it myself. And I said, well, why are you going to do that? He said, well, myself and this young lady, we're back together and everything's okay. And she doesn't want to prosecute me. She doesn't want this to go, so she's going to go with me. And it's all going to work out. And we just don't need you to go, and we don't need this whole trial, and we'll just take care of it. And I said, this is not a good idea. You need to let me handle it. I understand your thought process, but that's not really the way the court works. It's not so black and white. And he said, no. I said, look, this isn't about the money. This isn't about money. You're not making the right choice. He said, this is what I'm going to do. I appreciate your help. I appreciate everything you did, but we're going to be fine. We just want to move past this in our lives. I said, all right. So I kind of forgot about it, got busy with other cases. To be honest, was glad he didn't ask for any money back, and was just moving on. And about 2.5 weeks later, I'll never forget this guy's name was Craig. I won't recall his last name. I wouldn't say it anyway, but he called the office and said, Craig wants to speak with you. And I said, I don't know what this is about. So I answered the phone and I said, hey Craig, how you doing? And I had remembered at that point, who he was, obviously, and the case was coming up, but I couldn't even recall when the court date was. It really wasn't in front of me. And the first question he said was, I was really busy that day, and he said, David, what do you know about working on jet fuel engines? I said, Craig, I don't know anything about working on jet fuel engines. Why? And he goes, well, that's about how court went for me yesterday. So the point of that being, he went to court with his love. She got on the stand, wanted to say, I don't want him prosecuted, don't want anything to happen. The prosecutor said, that's fine, we understand you're back with him and you love him. We appreciate that and we're happy for you. But on October 17th, 2012, did he slap you? Well, yeah, he did, but he didn't mean it. He was mad at me. No further questions. He was found guilty in 5 minutes. So So the point of that being, he represented himself because he thought it was as easy as, like, if your two children in the schoolyard tell the teacher they're both sorry, they just want to move on, and everybody moves on. Well, that's not the way the legal system works. Now, there is ways that when you have a victim that is compliant and wanting to, drop the charges, get them dismissed, get them to at least consider other remedies, yeah, that can happen. But just walking into a court, kind of telling the court, hey, we don't want to move forward anymore, that's not the way courts work, and it definitely isn't now. This is before we really saw the turn up of enforcement of criminal domestic violence here in South Carolina, related actually to an article through the Post and Courier. Now it would be even more. Now victims even can jump up and down screaming, and they still won't dismiss it because it's the state's case. But other examples of talking about you can represent yourself, and this is something we do have problems with, is you're hired as the lawyer, you're appointed as a lawyer, or you're the public defender, and the person that, whether they be in jail or out of jail, they think they're a lawyer too. Especially if they're in jail, they become what you call a jailhouse lawyer, and they want to start making decisions off what they think is right. And you can get very far in a case with someone and have a lot of issues to the point you end up having to get yourself removed. This happens in civil cases too. You try to explain to your client that you think that they should settle for a certain amount of money. They want a bunch more money. They think they deserve that more money. And maybe in reality, they kind of do deserve that amount of money. Maybe they really were that hurt, for instance. But what you know is the law side of it, and you know the legal arguments that the other side's going to use. And they're only purely looking at it emotionally. And I have a case right now, otherwise I'd give you the exact facts. But I'm now putting in a motion to be relieved because of that exact reason. Because the client and I don't see eye to eye. But ultimately, the client is the boss. So if you can't get along with your boss, then you have to leave your job, or you have to ask a judge to let you leave your job. So that's where the participation on both the criminal and the civil side really can be very frustrating. The best type of client that you can have is one that says, this is your case. It's no different than, I always say, and you can Google law stuff, but I can only imagine what it's like to be a doctor in today's world when people walk into a general practitioner's office and tell them what they have because they've looked at WebMD or Google or whatnot. That's got to be very frustrating and almost humorous sometimes for doctors, because the person walking in there that may be a great carpenter, hasn't gone to medical school, hasn't seen these conditions over and over again. They've read a few articles and blogs online and say, yeah, that's why my shoulder feels this way, and they've diagnosed themselves. You have similar types of scenarios within the law. Any next question? Do you have a question?
Next question? Yeah. Y'all can jump in. How do you go about setting your fees? I know, some cases, the insurance, once you get a percentage of
Contingency, right?
that, but.
So, well, on the civil side, you have two ways to really look at it. You can be hired per hour, basically, on a time retainer. So for instance, let's say you have some sort of business litigation. It's not really about you getting a certain amount of money from another business, or you going up against the city. Let's say you have a city ordinance. That's a case that I just recently got. There's a city ordinance, and it's in a local community here in the Lowcountry, and a business hires me to fight that ordinance because that ordinance would hurt their business. Well, there's not going to be any money if we win against the city, meaning we wouldn't be able to sue them and get damages per se. Sometimes you could if it's unconstitutional, but generally speaking, my job is more of a bully pulpit to pull up legal issues and things to just make that ordinance go away. Well, that would be the type of case you would either take on a flat fee, or you would take on a retainer that you'd be working time off. So like X number of dollars per hour, $200, $300 per hour. The other type on the civil side is going to be contingency, and we all see the TV commercials for the lawyers on TV and say, you don't owe me a cent till you're paid. And what that means is you get, let's say, use the easiest example, car wreck case. It's not your fault. You get injured, you break your arm in a car wreck. Well, they bring a case against the driver of the car, which essentially means the insurance company, and then they work the insurance company to get a settlement. So then once that settlement comes in from the physical therapy, all the other bills that you have related to it, and of course pain and suffering, which there's no exact number on that, then they take a percentage of that. The normal percentage is somewhere around 33% or 1/3, going up to 40%, and 50, and depending on if it's a trial and that sort of level. Obviously that can be negotiated, can go lower. So those are the contingency cases. So that's what you see on television. Now, criminal is completely different. Criminal is up to you. You know, you can decide to represent somebody for free because it's your next door neighbor and he or she's a good guy. You can represent someone and charge them maybe 2 times what you would normally charge a person because of the type of case it is and the type of person you think you're going to have to deal with. There's an old saying about lawyers that, you know, when you have somebody come in and you can just tell it's going to be a very difficult case and it's going to be a very difficult client. So you charge them an enormous fee. And you win either way. And the reason you win either way is either A, you get that enormous fee and it's worth the hassle of dealing with that client, or B, they don't have that enormous fee and you don't ever have to deal with them again. So it's on a case-by-case basis. And also there's a level of competition with it. So, I mean, certain types of cases, you know, as far as the value, one easy example to give is in my practice of only 12 years, you know, the value of what a driving under the influence case was back when I first started and what a defense attorney could charge compared to now, it's gone down a lot. And the reason because that is because the market's gotten flooded. There's so many more attorneys in Charleston since the law school started. You have a lot of people that come here and then they enjoy working here during the school year and they enjoy working and clerking for judges and lawyers during the summer. And then guess what? They don't want to go back to whatever hometown they're from afterwards. They want to stay in Charleston, go to the beach and go to all the nice restaurants and fun places around here. So they, you know, get a job here or they open up their own practice. And so the market in our small state has really gotten flooded, but particularly in Charleston. So some of it is based off just basic economics.
When you ever have to eat your fees because the person doesn't pay you?
All the time. You know, if you're a criminal attorney, if you're charging criminal money, obviously you have those cases that, you know, you have at least a minimum you want to make. When I first started, I had a lawyer that I had worked for in college, who's still one of my mentors. He's retired now, but he told me, you know, in a criminal case, oh, when you quote a fee, just whatever you quote, be happy with getting half that amount. So I went back to him about 2 years later and said, you lied to me about that fee thing. He said, what do you mean? I said, you told me that when I quote a fee to be happy knowing that I'd get half that, if I could get half that amount. He said, yeah. I said, it's not half, it's a third. So yeah. And depending on what level your practice is at. I mean, there's some lawyers that are in the fortunate position, whether it be because of other financial interests they have or just their position in life, that say, hey, this is my fee. If you want to hire me, you bring me this amount. If you don't have this amount, I understand, I can refer you to some other great attorneys, but this is what I want, and I got to have this now to get started, otherwise I'm not going to touch it. So that's going to be on a, you know, just depending on the person, how many mouths they got to feed, how many bills there are, that sort of thing.
How come you're not on TV?
As far as why don't I do commercials?
Yeah.
You know, I've done some with, I do one division of my office is Riders Law Group, which is motorcycles. We do a lot of motorcycle representation, so we have some commercials directly to that. But as far as doing just basis campaigns, one, you don't see anybody really do a lot of criminal defense type of commercials, just because criminal law really has a sort of a ceiling. There's really no such thing, even in big cities like New York City, you don't see huge criminal defense firms, because the bottom line is there's always going to be a lot of criminal lawyers, different options and good options, and there's only going to be so many people that have money to be able to afford a criminal lawyer. You know, I've had different people say when you open up an office in a certain area, oh, well, there's a bunch of crime about, you never run out of business. Well, there's a difference between people committing crime and them or their families or friends being able to pay you to represent them for getting accused of committing those crimes. So from a criminal standpoint, that's why you almost don't see, now I've seen them in some other markets, but you don't really see a whole lot of that at all. Now from the civil side, we obviously see there's nonstop commercials, particularly for, you know, car accidents, workers' comp, things like that. And it's not that I'm against it or you know, wouldn't do it at some point in time, depending on the circumstances. But I feel like that it kind of blends you in a lot with other attorneys. And if you can sort of market in other ways, such as being at a local library on a Saturday afternoon at 3 o'clock and talk to some folks that way, you get a more personal touch. And the other side of it is, honestly, is just you have to look at it from a monetary standpoint. I know a lot of good friends of mine that are attorneys and good attorneys, and they put money into commercials and not seeing the results they wanted, and that's simply because it takes a lot of repetition, which takes a lot of money, and it's even more now than ever. And there's also, I think, more productive ways, and I think a lot of lawyers, younger lawyers, are seeing and changing that and putting their money in internet-based marketing. Yes, ma'am.
If anyone wanted to learn more about law or about this subject, are there any sources out there that you
Like
could
law
back up?
attorneys.
Any like really vetted quality websites, or what's your favorite book? Or in the library, what's your favorite book on
You know,
this topic?
the best thing that I think people can look at before even trying to get into, well, there's, I guess, two sides of that. One, there's several different books that probably more now than there was even when I was first starting out, is reading about sort of the basics of, one, going to law school. You know, law school on average is 3 years. That can get very expensive depending on where you go and what kind of scholarships you have, and also depending on where you are in your life. So that's the first thing, because you got to get past that. We don't, at least here in South Carolina, live in a state that you can just take the bar without going to law school. We used to. In fact, Strom Thurmond did that. He was a PE teacher, and then he took the bar. Other states, there's a handful that you can still do that. But if you want a South Carolina bar license and get it from here, you've got to go to law school and get the law degree. So what's I always tell people most important is understand that process. You know, being a lawyer in a lot of ways can look cool or seem exciting or seem interesting, but sometimes the process to get there is not what someone would really want to do, and the time that they want to put in, and the resources and everything else. As far as actually working or becoming a lawyer, maybe not even specific to what type of law. Today I've talked about criminal and civil sort of trial litigation. You could have a real estate lawyer or probate lawyer come in here and not mention a word of anything I've said other than client. So all those things sort of come with due time. But for me, I was just 18, I guess, and I was just a kid with a car that really needed some extra money, and got a job at a law firm only because they're the ones that hired me as a runner, no more than I could have got a job at the library or at a burger joint. And I just got exposed that way based off, not because, man, I really want to be a lawyer. I didn't come from a family of lawyers or anything like that. And it was just being in the atmosphere of it. So you don't have to actually be a law clerk or do, anything like that. I've got a young college student right now that works for me that's college student in the College of Charleston. He went to a pretty big indictment hearing with me in a state attorney general indictment in Columbia the other day, and that was simply because he lives there and had to go get me the files for it. He got to see something that I had never seen until I was probably 5 years into practice, and he's 19 years old. And that doesn't mean he was going to make him want to be a lawyer or that type of lawyer, but just the more actual exposure you see from sort of a background standpoint, I think. I know a lot of people that have worked at law offices that that's not what I want to do. Those people look too stressed, and those clients are mean, So it could be a good way to sort of push that idea out and look into other types of law, or other types of careers rather. But there are plenty of, as far as books, whether it be here's what a lawyer does or here's how to get to law school, there's some great resources that, and some of them are written by ex-lawyers, some of them are written by lawyers that have done really well, and other ones are written by people that quit law school. So you have a good variety of those.
Jury consultants, does that happen much in South Carolina?
It does on bigger cases, that when you have, and obviously criminal cases, you don't see a lot of it because honestly the clients just usually can't afford it. It's very expensive to get jury consultants involved in cases. And for those that don't understand what she's referring to, you have actual professionals from various backgrounds. In fact, Dr. Phil, if you're familiar with him, he was a jury consultant. And they look at types of people's personalities, they look at psychological things, they look at the type of case it is, and they really help try to determine what type of jurors you would want to pick. Now on the civil side, particularly if you're talking about, let's say, a medical malpractice case or a products liability case, a case that's going to be worth a lot of money. You may have already gotten a really big offer on it. It is worth the plaintiff's side to spend the money to get jury consultants, not just jury consultants, to actually have mock trials. Well, they'll go through an entire trial. They'll have lawyers play the other side. They'll put facts up in front of a jury, and they'll go through entire cases to prepare the best way that they can. Again, could you do it for criminal? Are there lawyers that have done it? Of course. But the resources are different there. With the criminal, if you win the case, we don't set cases. It's not ethically right. So for instance, you can't say, okay, you're charged with murder. I'm going to charge you $75,000. But if we win the trial, you've got to pay me another $75,000. You can't bonus structure it. Now, you can set your fee to say, if we go to trial, I need another $50,000 for my fee, and I need $25,000 to put in escrow, which would be used for experts and different types of experts you would use in cases. But jury consultants, some people say, oh, I don't need them, but they absolutely can help. And when you have cases that are going into the 7 and maybe 8 figures, it's worth the investment for either side, defense or plaintiffs, in civil cases to use them. But it'd be nice to have a client on the criminal case that would, be able to put those resources together. Unfortunately, within a lot of criminal cases, the reality of it is when you get to trial, the amount of hours you put in, you're lucky if you break even comparatively to what the fee is. I have a good friend, I will not say his name, who once tried a murder case for $300 because he got on the case quickly and thought this other money was coming in and never came, and he tried to get off, and more or less the judge told him, your practice and your business within your practice isn't a concern of the law or this courtroom. You signed up and filed to be this attorney. You'll be the attorney. We'll see you on Monday. So he tried the murder case for $300, and he had to try it as hard as he possibly could. No different if he'd gotten $300,000. So the money component is an interesting play, particularly on the criminal side. But any trial attorney that tells you they didn't either give their time free or literally spend their own money on expenses in a criminal trial probably has never tried one, because unfortunately that's what it comes down to a lot.
Have you ever refused a case, or your colleagues, is this practice at all based on the nature of it? You realize you can't detach yourself from,
I don't.
you find it personally.
A good example of that, then I know a couple of very good attorneys that are good friends of mine. They won't take any cases related to child molestation or child sexual cases. I don't do that. And I know other attorneys that just won't take federal cases, or not even just topic specific. They just don't want to do that type of work. I personally don't. I can understand why people don't. Sometimes people don't do it based off a moral issue as much as they do it off of the familiarity of the type of case. But when people ask you, you get a lot of the criticisms from representing sometimes. In fact, there's just recently with Harvey Weinstein, a Harvard professor that more or less has now been let go, and he and his wife, and she was a dean there, and when he began representing Harvey Weinstein and his cases in New York, and there's a lot of uproar about that because regardless of what the students think of Harvey Weinstein, he still deserves the defense. And so I don't have that issue. I think a lot of times what you usually hear people say about criminal defense attorneys is, they're sleazy and they're bad people all the way up until you get arrested and need one of them. So, but yeah, you have definitely know people that won't represent certain types, and I would say probably the one that comes up most often to me, or that I can think of, is related to anything to do with children, particularly.
That's kind of what I had in my mind.
Yeah,
but you're well within your right to do so.
Right, and personally, I've represented tons of folks charged with some pretty terrible things, done from child all the way up to elderly person. And if you can't detach yourself from it and handle it as a case, then you may not be in the right type of law. Is the way I look at it. You're not a drug dealer just because you represent a drug dealer, no more than you're a child molester just because you represent somebody that allegedly molested children. But yeah, you see people sometimes to the point they can't deal with it, they change, their type of practice even, and ultimately. Or some that can only see themselves as trying to prosecute those type of people and are with, lifelong prosecutors, which are sometimes the most difficult to deal with in cases, and other times the easiest because of their experience. Some have that justice road the whole time, and then others are a little bit more reasonable and understand how the system works. But yeah, so for me, I've never had that concern. I've heard some concerning fact patterns, cases, and then I also get the bills that come in the mailbox, and so you kind of balance the two out and figure out what you want to do.
Thanks.
For anyone who has sat in on a trial, and I've sat in on several, the back and forth between prosecutors and solicitors gets pretty heated. There's a lot of sidebar stuff like that. I think Scarlett's probably one of the best at the eye roll towards the jury. But you guys are all members of the bar. I mean, is there a contentious attitude between you guys outside the courtroom, or are you just friends?
That's a very good question. I think you've actually seen it live yourself in a courtroom. A lot of people are just going by what they see on television, like Law and Order, where the police are talking to somebody, and then all of a sudden the door kicks in, and the defense attorney grabs his client and says, we're getting the heck out of here, and screams at everybody. That really never happens. You're exactly right. That one case shouldn't ruin a relationship. So yeah, there's times within a case things get very heated. Frustrated, whether you're frustrated with the judge or you're frustrated with the other side. But I'm very close with a lot of people that are at the Scarlet being someone I've been close friends with for a long time. But if we have a disagreement, it's going to not look like that we're very good friends sitting in that courtroom. But if you know us, you might see us the next day speaking together at a conference or having a cup of coffee, because you just have to be able to separate themselves. That's not to say that under certain circumstances within a certain case that angst can't be built up or whatnot. And there are some attorneys I feel like that do take things maybe more personally than they should. That's never really been a problem for me, because if you really just dial it down to the scope of that one case, and as long as someone's not doing something unethically, you may just disagree with their argument legally, or how they're handling a certain type of situation. But yeah, I mean, at the end of the day, you're really going to have a problem if you sort of have that us against them mentality 24/7, because that one case is going to go away pretty quickly, and if you're going to continue to practice within that area. There's not a lot of criminal defense attorneys that, for instance, in this state, which is a very small state, we all could drive, from one end to the other in a day and back. But you don't take a lot of cases in other bars. Like, for instance, you wouldn't have a lot of Charleston attorneys taking a whole lot of Greenville County cases. You may get one or two occasionally. You wouldn't have a lot of Spartanburg attorneys taking cases in Columbia. So you really stick with sort of where your area is, and a lot of that has to do with your reputation and name, and just how people know you. You go to church with them, you live down the street with them, you know them through business contacts, and that's where your client base is. So you're going up against those same prosecution, or at least those same offices. Now, sometimes those people may leave, and sometimes you're sad that they leave, and then other times you're really happy that they left. So both of those, but at least for me, it's never a personal matter. But just human nature for the frustration to come out. And that brings up a good point, going back to the jury thing. I am a big fan of making over-exaggerated facial expressions to the jury, either kind of smirking like, oh, that was really stupid what that witness just said, or just shaking your head, or just different little things. And you have no idea if they're even really looking at you or paying attention. But if you have their influence, you have influence over them all, and they like the way that you've sort of brought yourself around the courtroom, that actually can make a small difference. Not, that they're not going to just ignore facts or anything like that because they think that you're funny in the courtroom, or they think that you made some good remarks, or that you're wearing nice shoes or anything like that. But it can come into play on other levels. Yeah. How about in the back? You've been writing a lot of stuff down, so there's got to be some question in there.
I don't know.
She's taken a pre-law class in school,
Yeah.
and we're friends with Nick.
Well, those are the best way. Also, you going back to what you said, those classes, and I know when I was in high school, there was a couple times that attorneys would come and speak, but really what helped me sort of understand law when I got into my later years of college, probably junior and senior, was having adjunct professors that were actually practicing different types of law when I knew I was going in that field, or thinking about it at least. Political science was my major, but I had several classes that were taught by adjuncts. And it was great to have somebody that literally would walk in from maybe even legitimately a courtroom hearing and walk into your classroom and start teaching your class. Now, they still have a book and they still have things they have to go by, but the stories that they can tell and the examples they give you a good illustration of sort of what everyday practice is like, or what that type of practice that person. And I could name 2 or 3 from the College of Charleston that still to this day I remember some of their stories, and they were very influential. And by that point in my college career, knowing that I knew I wanted to be a lawyer, as opposed to still just not really being sure, because that's one downfall with law. It could be considered something that's positive, is unlike med school, engineering school, different things like that, business school. You graduate from college, you don't have to have a degree in anything related to law. Well, you said it's a pre-law class that you're in. Those are great and they help. But I went to school with everybody from that had a math degree to a computer design degree to some sort of basically fashion design degree. And the point of that being, there is no prerequisite as far as the type of degree that you have to go to law school beyond just having the undergraduate degree in and of itself. And then of course your LSATs. So that can be good and bad. It's good a lot of times because you get people with diverse backgrounds. It can be bad sometimes because people go to law school just because they can and they feel like this is a good answer for their parents or their friends or society that they're going to law school. Then when they get in there, it turns out to maybe not be exactly what they thought it was going to be or what they really want to do with their lives. But to the positive side, having a law degree, even without passing the bar, there's a lot of people that do that, can open a lot of doors in other professional fields as well. If you look at the amount of CEOs of companies and things like that that have law degrees, it's very high percentile that maybe never mention the word law, maybe never even practice law a day in their life. Like I said, some don't ever even take a bar exam in any state, but they do have that legal perspective and that legal background. So I think that goes a long way too. But that's a lot of school not to use the law degree as far as I'm concerned, but it all depends on who you are and what opportunities you have. Any other questions?
I'll make it easy. I probably have a million more, but on TV you see where they advertise that they got they won some big case, product liability and that kind of stuff, and then they encourage you that there's X amount of money in a trust or something to cover future litigants. Does that?
Yeah, what you're talking about, mass cases, right? So these mass tort cases where there might be some sort of defect claim, right? And then when you have that type of claim, that they've already they put a group together is the best way to describe it. And then what happens within that group, they can bring on more to the party, and so that's where you end up. What that party ends up becoming is a class action suit. So it's a huge group that can go against. Let's give an example. Think of a car. Let's say Ford had.
I don't use Ford.
Okay. What was one years back that they was it Toyota or one that had the engines that would blow up, and so you have these car manufacturers and there's some part that is defective, and there's been hundreds of thousands of these cars bought, and maybe your car hasn't blown up yet or you haven't had that defect, but so many people have, and the ones that have, and so that's where you end up forming a class. And what those commercials you're talking about is is joining that class, because obviously the more that are in the class, the stronger the claim is, and that class has already been certified within some court, and then you just kind of follow along with that. So in those type of cases, for instance, if it was an asbestos case, there used to be so many types of asbestos cases, there was a lot of class action suits with that. Another one that was popular down here, because it really started here, was tobacco cases, and there was huge class action suits. For instance, the latest one that I just saw the other day, this class action was the Las Vegas shooting suit with MGM. I think it's going to settle for $800 million for victims of that suit. Now there may be other pots that they go into as well, but at least from the MGM part, from that mass shooting that occurred on their property, that was the number that I had recently read in an article, and that would be like the type of where you could get a class together. But that doesn't mean you can't also sue individually. So what they're looking for in those commercials, they're soliciting for people that took that kind of medicine too, and maybe they also have that same side effect. Well, now they can join in as well, and maybe they hadn't heard of it or didn't know, and so they're encouraging those people to join in with them, and then they'll try to evaluate and see if you actually are a person that would fit within the class based on a lot of different circumstances.
All right, are there any other questions?
That I was going to ask him now.
I think there were a lot of good questions asked today, so thank you everyone for coming.
Thank y'all for having me.
Thank you, Mr. Aylor, for being here, and please feel welcome to check out the book display in the back, and if you really enjoyed Human Library, please visit ccpl.org.
And take as many cups and koozies as you want back there, otherwise they'll just stay for the next group.